Welcome to my lecture on intellectual property rights. This is the second video in this series, and here we are going to cover what exactly the intellectual property is, and then what are the various forms of intellectual property. Okay, what is the basic difference between human beings and animals? Right? What is the basic difference? Beings have some intellectual skill. Okay, this is bestowed to us by God Almighty. So human beings have some amount of intellectual skill, but animals doesn't have it. So any property which is created by application of human intellectual is termed as intellectual property. Okay, so any property which is created by application of human intellect is called as intellectual property. See, only the idea if a person is having, then it will not become intellectual property. It should have some intellectual ideas plus labor. So, intellectual property is a product of intellectual capability and labor. Let's see another definition which clarifies in more detail about what exactly the intellectual property is. It's according to WIPO. WIPO stands for World Intellectual Property Organization. Intellectual property refers to creation of the mind. Very simple. Anything which is creation of the mind is called as intellectual property. What are those? Those are inventions, literary and artistic works, designs, symbols, names, images. All these things are called as creation of minds, and this will be qualified as intellectual properties. Take an example for invention. What exactly the invention is? Batteries, right? We use batteries every day, one or the other form, like whether it is in a car or in mobile or in laptop or inverters, what we use, UPSs we use in house. Everywhere we use a battery, and the battery will drain out based on the usage. Correct? Your mobile battery will be drained out in hours time if you use it continuously. Otherwise it may come for 24 hours. It is all based on usage. So if anybody produces a manufacture if produces a battery using the same technology which will drain out based on the usage, then it is not invention. Invention is something which, okay, here what we have given, Mr. A invented a new battery which lasts for 10 days, irrespective of the number of hours usage. If any new invention, right, there should be something new. Otherwise, it is not be called as invention. Okay. So here what we can see now, earlier the battery used to drain out based on a usage. Now, irrespective of the usage, the battery will come for 10 days. Whether you use it for 1 hour or you use it for 20 hours in a day, but battery will come for 10 days continuously. So this will be qualified as invention. And with the same way, literary and artistic work, the book written by a author, that is a literary work, or the painting done by an artist, it is an artistic work. All these things will qualify as intellectual property. The idea which will help to produce a battery which will last for 10 days is an intellectual property. Not the battery which is produced using that, but the idea itself, that the whole concept, not only idea, the whole concept of how to produce battery with, which will last for 10 days, right? That itself is an intellectual property. The same way, the book written by an author is an intellectual property. The content within that book should not be copied and used by others. Okay. So otherwise, the other things what we discussed, designs, the bottle design of a Coca-Cola, the symbols, logos of a firms, or names and images, all these will qualify as intellectual properties. I hope you guys are clear with intellectual property, what exactly it is. Protecting these creation is a main function of intellectual property rights. There are many IPR laws. Why these IPR laws have been developed? To protect the intellectual developments or creations of the mind. If anybody done a new invention or if anybody written a book, all those persons' rights should be protected. So the IPR's core function is to protect the interest of the creators. Okay, moving on. According to WIPO, intellectual property rights shall include the right relating to what all that IPR is going to protect. Okay, if I write a book, literary work, artistic, scientific, or any other research, then that will be qualified for intellectual property rights. Protection under intellectual property rights. The same way, any performance of performing artists, broadcast, phonograms, all these things will be qualified for intellectual property rights. Protection under intellectual property rights. And inventions, scientific discoveries, industrial designs, trademarks, service marks, and commercial names, protection against unfair competition. All these things are qualified for intellectual property rights. So we understood now what is IP, intellectual property, what is the main focus area for IPR, intellectual property rights, and what is the scope of IPRs as per WIPO. See, all these 3 points we discussed here now. Any person, like some A invented battery, if it is unauthorizedly used by others, is called as infringement. Any invention, if is used by, or any IP products used unauthorizedly, is called as infringement, and these are punishable offenses. Okay, without the permission of A, no one should use, no one should produce, no one should sell those products. Okay, so this is in brief about what exactly IPR means, IP means, and IPR means. Let's move the various forms of IPR. Let's discuss various forms of IPR. In the initial video, in the first video, we discussed there are two kinds of properties, tangible and intangible. IPR deals with intangible properties. And in intangible property, we have two further classifications. One is industrial and then non-industrial. Industrial properties related IPRs are patent. Industrial property related intellectual properties are patent, trademark, GI, and design. And non-industrial side, the intellectual property is copyright. Okay, let us see these 5 major classifications one by one in detail. What is patent, what is trademark, what is GI, what is design, and what is copyright. Patent, most important out of all other industrial intellectual properties. Patent. What is patent? Patent is a statutory privilege granted by the government to inventors. Okay, say example what we took. A invented what? He invented battery which lasts for 10 days. When A invents it, he might have spent huge amount of time on that. He might have spent time, he might have spent amount, everything he has to recover it before others use it, right? So he should get some time to produce and sell it and make a money for his initial investments and initial time. To do that, government give a statutory privilege. Who? Government provides a statutory privilege to inventor to produce sell, and use the invention. And no one else should use this particular patent, this particular process, or this particular product. No one should produce, no one should sell it. So, patent is a statutory privilege granted by the government to inventors and to other persons deriving their rights from the inventor. For example, if A invented a battery and he may ask B to produce it, he may ask C to produce it through license agreement. Okay, you produce it, you say you provide me 20% as a commission to some agreement. If B and C enters with the A and B and C takes permission from A, then they can produce, they can sell the product. So it is a statutory privilege granted by the government to inventors and to other persons deriving their rights from the inventor. Okay, B and C, they derived this right from A. Okay, deriving this rights from the inventor for fixed years. Okay, when A gives a grant like permission to B and C, he will say you can produce it for 5 months or you can produce it for a fixed region. You can do it in only a North India. C can do it in South India. Some kind of fixed time and a fixed duration or a region will be given. Okay, to exclude other persons from manufacturing, using or selling patented product and processes. So government will restrict all other persons other than inventors and the persons who have a right to produce that, who have taken it from inventor. Excluding those parties, no one should produce or sell those products. Example, Covaxin, which is Indian invention for a COVID protection vaccine, should not be produced and sold by any manufacturers for next 20 years. Every patent period is, once the patent is registered, then the validity will be for 20 years. Hope you guys are clear with what exactly the patent is. Now moving to our trademarks. Trademark means a mark capable of being represented graphically and which is capable of distinguishing the goods or services of a one person from those of other. For example, we know that if you see Coca-Cola bottle, immediately you will come to know that it is Coca-Cola, right? No one needs to tell you because the Coke branding on that and the design packaging, everything will come to know that it is a Coke. Or if you see any product with this logo, we will clearly say that it is Tata products. So any mark which will clearly distinguishes from other products and makes that okay, this is from this particular business entity or a business group, that will be called as trademarks. So Pepsi is a trademark for Pepsi company. PepsiCo always uses Pepsi as trademark for their product. Coca-Cola is a registered, no one can use this, right? Coca-Cola is a registered trademark of Coca-Cola Inc. Okay, this trademark can be graphical thing or it can be a name or it is a color, anything, but it should distinguish from one product to other product. Okay, that is called as trademarks. Generally, trademark once given that will be valid for 10 years and then it can be renewed multiple times. Third important thing is geographical indication GI. Very simple. Sometimes people get confused with what exactly is GI and what exactly the trademark. Trademark says that who is a manufacturer of it, right? If you see the symbol of Tata, then we say that this product is manufactured by Tata Group. But geographical indication says that origin of the product, not the maker of the product. For example, you might have heard many products which is suffixed with city name or a state name. For example, Kanchipuram silks, Mysore silk saris. Kashmiri Pashmina shawls, Agra Peta, Darjeeling tea. All these things, products are suffixed with the location of it, right? Mysore silk. Why? Because these particular products are produced in that particular region of a country. Most importantly, those products will be produced in that particular region, and because the ingredients of that will be available in those regions. So if somebody is selling Mysore silk sarees in northern part of India using the silk which is available there and but calling it as a Mysore silk is an offense, because Mysore silk will be made with threads silks which is available in the region of a Mysore, which is more softer compared to other silk threads. Okay, so that's why the customer should not, or a buyer should not be buying a fake geographically indication tag, because Mysore silk is a world famous and just other persons are using it without using the quality of that Mysore original Mysore silk, right? So buyer should not be cheated, or a fake should not buy fake GI tagged product. That's why GI registration has become more prominent in the recent times. Okay, so GI tells us the origin of the product. Okay, it is specific to some region. Okay, because of that reason and that historical reasons, it will be having some reputation and some characteristics of the goods. So every product which is produced should have this kind of characteristics. Otherwise, it will be unauthorized use. It will be called as unauthorized use of GI tags. So Mysore silk sarees is a tag associated with Karnataka Silk Industries Corporation KSIC, and anyone who is associated with KSIC can use GI tag. Any manufacturer who is associated with KSIC can use GI tag. Remember, trademark, if I get an idea, okay, tomorrow I want to register my business with this kind of a logo, I can go and register it. If no one is using this, they will give it trademark. But GI is not like that. You can get GI only if there is a history for that product. Okay, Mysore Pak, Mysore Silk, Pagdi chilies, Guntur chilies, all these tags, Ratnagiri Alfonso, the name will come with an history of that product. People should consume it for more number of years, and then only GI tag will be provided. It is not based on ideas or anything. It is based on historical consumption and historical reputation of the product. Okay, moving on. Designs. Design protects the form of outward appearances. It is nothing to do with the product characteristics or something. By seeing the design itself, right? If you see the chocolate, which is having these kind of breaks in between, we will easily say that it is a Kit Kat chocolate. A chocolate again which comes with toy here in a egg shape. So then it is called as Kinder Joy chocolate. The same way, car designs, by saying the car design itself, you can say which car is this. This external appearance or aesthetic styling of any object is qualified as a design. No one should copy that design and produce the same. See, if a Maruti has designed a car, if someone else uses that same designing, the recently we saw XU 7 and 700 from Mahindra. If someone copies it and make the same kind of a car design, then it is an infringement. Okay, design deals with outward appearance or aesthetic style of a product. It will not add any value to the product functionality. Copyright, fine. The copyright protects the literary and artistic work. If any author writes the book, he will get the entire right of that book. The same, otherwise the publisher, where the based on the agreement, and then music director who creates the music. All these things are artistic work or a literary work will come under copyright protection. Okay, so summarily, patent is for invention, trademark is for business names, geographical indication is talks about origin of a product, origin place, design is for external appearance of the product, and then copyright is for literary and artistic works. These are the five major classification or forms of IP, intellectual property. But apart from that, we will also discuss many other subvariant or related things during our discussions, like plant varieties, cyber security, and then software protection. Okay, all these things we will discuss in our coming videos, other intellectual property related types. But these are the core basic fundamental intellectual property forms. I hope you guys are clear with the concept of intellectual property, what exactly the intellectual property is, and then what are the various forms of intellectual property. With this, I conclude today's video. Thank you for listening. I request you to subscribe this channel. Thank you.